Okay, let's dive right into this explainer and unpack what at first glance looks like a super dry bankruptcy dispute. But trust me, it actually turns into this profound, high-stakes battle for fundamental human rights. We're looking at case CCT 2697 DeLonghi versus Smuts. It's an absolute landmark ruling that really tests the limits of state power when it comes to your physical liberty. At its core, it asks one huge question: who exactly holds the keys to your freedom?
Picture this scenario for a second. Can a non-judge, someone who isn't even part of the judiciary, send you straight to jail without a criminal trial just because you refuse to answer questions about a bankruptcy? Well, that is the exact dilemma Douglas Michael DeLonghi found himself in. He was summoned to a creditors meeting, point-blank refused to hand over certain financial records, and, bam, ended up with a prison warrant issued against him by the presiding officer. This kicked off a massive legal showdown over how far the state can actually go.
To see how the Constitutional Court untangled this mess, we're going to follow a pretty straightforward roadmap today. We'll start by looking at the whole idea of going to jail without a trial. Then we'll dive into the right to freedom itself. From there, we'll break down the why, is there a just cause, and the how, was there a fair procedure. And finally, we'll bring it all together with the separation of powers. All right, let's kick things off with Section 1. Jail without a trial? Let's take a closer look at the mechanism that actually put DeLonghi behind bars. So the whole thing hinges on a law from way back in 1936, the Insolvency Act. Basically, this is a law that allows creditors to interrogate individuals and demand documents to figure out if there are any hidden assets during a bankruptcy. DeLonghi was committed to prison under a very specific part of this, Section 66(3), simply because he wouldn't cooperate. The statute actually authorizes the presiding officer to issue a warrant, committing a stubborn witness to prison until they finally agree to cough up the information. It sounds incredibly harsh, right?
Let's move to Section 2 and see how the Constitution pushes back. We're talking about the right to freedom, specifically the shield provided by Section 12(1).
When analyzing this, Justice Ackerman did something really clever. He took this broad right to freedom and cleanly sliced it into two distinct pillars. First, you have the substantive right under Section 12(1)(a). That's the right not to be deprived of your freedom arbitrarily or without just cause. Basically, this is the why you are being detained. The state needs a valid reason. Then, you have the procedural right under Section 12(1)(b), the right not to be detained without a trial. This is the how you are detained. The actual process has to be fair.
Which brings us to Section 3, the why. Is there actually a just cause, a genuinely valid reason to lock up someone who just won't talk about their bankruptcy?
Well, the court said yes, absolutely. There is a deeply compelling, constitutionally valid public interest in coercing people to hand over this kind of information. Think about it from a trustee's perspective. When they take over an insolvent estate, they usually have zero clue where all the money or assets went. So locking up an uncooperative witness is pretty much the only way to protect creditors' rights, expose any shady or collusive dealings, and recover those hidden assets so everything can be fairly distributed. If the state didn't have this power, the insolvency laws would literally be toothless.
And this leads to one of my absolute favorite concepts in this case. The court noted that this is a classic example of civil contempt. It's coercive, right? Not punitive. The detainee isn't serving a fixed 6-month sentence for committing a crime. They are just being squeezed to comply with a legal duty. As the court so brilliantly put it, they literally carry the keys of their prison in their own pockets. The exact second they decide to cooperate, they walk free.
Because of this dynamic, the court ruled that the why is totally above board. The state definitely has a just cause to restrict physical freedom to enforce these bankruptcy laws. Committal under Section 66(3) is viewed as a coercive process in aid, rather than some arbitrary, punitive criminal sentence. It serves a crucial public objective and goes no further than what's strictly necessary. Okay, on to Section 4, the how. We know the why is valid, but let's look at fair procedure and the need for an independent arbitrator. Here's the catch, though. Even if the state has a rock-solid reason to detain you, the Constitution insists that the way they do it, the how, must be procedurally fair. Now, the court explained that the trial part of Section 12(1)(b) doesn't necessarily mean you get a full-blown criminal trial every time, but, and this is a big but, it strictly requires the interposition of an impartial entity. You need someone entirely independent of the executive and legislative branches to stand between you, the individual, and the awesome power of the state. Now, this is exactly where the Insolvency Act ran into a massive constitutional roadblock. The law actually allowed two different types of people to preside over these creditors' meetings. On one hand, the master of the high court could designate an officer in the public service, but these officers are part of the executive branch. They inherently lack structural independence because they answer to their bosses in the government. On the other hand, the law also allowed magistrates to preside, and magistrates sit in the judicial branch, meaning they are constitutionally independent. You can see the problem brewing here.
And that leads us into our final section, number 5, the separation of powers, where individual rights clash head-on with the foundation of the state.
The court essentially laid out a simple 3-step logic puzzle to show why this system was broken. Step 1, public officers are part of the executive branch. Step 2, because they ultimately answer to higher-ups in that branch, they lack objective, structural, judicial independence. Therefore, Step 3, they cannot constitutionally commit a witness to prison. Taking away someone's physical freedom is at the absolute heart of judicial power. You just can't hand that power over to an executive bureaucrat.
Now, we really can't ignore the historical context here. The 1996 Constitution wasn't just written in a vacuum. The court explicitly reminded everyone that it was drafted as a decisive, hardline rejection of South Africa's dark past, a time when executive officials had wide, terrifyingly discretionary powers to just lock people up without any independent judicial oversight. So the separation of powers isn't just some abstract legal theory in this case. It is a literal safeguard for human life and dignity.
So how did they fix it? It was actually a really elegant solution. They didn't just throw out the entire Insolvency Act. Instead, they declared Section 66(3) constitutionally invalid only to the extent that it authorized a non-magistrate, an executive official, to issue a prison warrant. It's a surgical fix. If a magistrate is presiding over the meeting, the committal is perfectly constitutional. But if a public service officer is presiding, they have absolutely no power to send you to jail.
So as we wrap up this explainer, I want to leave you with this thought. If the executive branch could lock you up without a judge just for staying silent about your finances, what would stop them from doing it for other reasons? This case is a powerful reminder that it's not just the rights written down on a piece of paper that matter, but the strong independent structures built to actually enforce them. That delicate balance of the separation of powers really is the ultimate protector of your everyday freedom. Something to chew on. Thanks for joining me, and I'll catch you in the next explainer.